We're on the record in the People's State of Michigan versus Dennis Justice, file 21-0108SM. Counsel, identify yourself for the record.
Daniel Duke appearing on behalf of Dennis Justice.
All right, today's time and date set for sentencing and a bond violation. My understanding is that Ms. Tidwell took into consideration the bond violation, if it were true, as part of her sentence recommendation. Mr. Duke, have you had an opportunity to review the pre-sentence report?
I have, Your Honor. I believe it's factually accurate. As far as I've gone over the recommendation with Dennis, we believe it's appropriate and ask that you follow it.
All right. Katrina, was there, the prosecutors indicated if a victim was planning to appear?
Your Honor, I did contact the prosecutor's office. They said they reached out to the victim and they said they did not wish to speak or appear.
Okay. Justice, anything you wish to say in your own behalf, sir?
No, sir.
Your Honor?
Yes.
I apologize. The prosecutor just sent me a message, and because I had told them that they had tried to appear, they're going to reach out to them very quickly. If we could wait just one moment to see if they are going to log back on.
Okay, thank you.
Your Honor, I did receive a message from the prosecutor. They did try to reach the victim, and the voicemail was full, so they were unable to do so.
All right. Well, I have reviewed the pre-sentence report. Mr. Justice, you have long criminal history, and then you have a long gap. Of not having criminal history. So you have the ability, but then while you're on bond, you decide to drink with your son. I told Mr. Duke that that deserves the recommendation for the weekend in jail, but as a practical matter right now, with having people going in and out of the jails, I'm probably not following that recommendation, not because it's not warranted, but because it'd be difficult to implement at this time. But I have no problems doing it and more if you do drink. It'll just won't be for a weekend. It'll be 5 days and then 10 days and then 15 days after that.
Yeah, it won't be a problem. I just relapsed that time.
Well, I think the recommendations as put in place, except for the one provision, are appropriate. I'm going to follow them, but I do need to read them into the record. So.
Okay.
It is the sentence of the court that you pay $75 crime victim rights fee, a $50 state assessment fee, $500 in fines, $475 in court costs. You'll be on 12 months of reporting probation. You shall attend and complete any counseling program to which your probation agent refers you to. Pay the fees, provide proof. You shall not possess alcoholic beverages, illegal drugs, or mind-altering substances, or recreational marijuana, or any derivative of recreational marijuana, including CBD or THC-infused products. You shall not enter any bars or places where the primary purpose is to serve alcohol. You shall not enter any place where where recreational marijuana is dispensed, grown, manufactured, or used. You shall submit to Scram alcohol tether for a period of 6 months and then follow all the program rules and pay the fees. Upon completion of the Scram tether, you shall submit to observed alcohol testing with no dilute, abnormal, adulterated tests as directed by probation and pay the fees. You shall not engage in any threatening, intimidating, violent, aggressive, or abusive, disorderly behavior towards any person. You shall have only peaceable contact with the victim, Lori Justice, and you shall have no contact with the victim, Lana Price. You shall serve 1 year in jail credit for 2 days served. I'm going to suspend all of those days except yeah, I'm going to suspend all the rest of the days. You have 21 days to appeal the sentence, 14 days request court appointed attorney to do that. Otherwise, we'll be adjourned on your case at this time. Thank you, Mr. Justice.
I have one question. Both of my jobs they serve alcohol. Is that a problem?
If you're working and not consuming,
Yeah.
if it's part of that, talk with Ms. Tidwell. We're not trying to make you change your profession, but we do not want you drinking.
I just didn't know.
No, it's good. It's better to ask and know up front. So typically if we have people that work in the restaurant industry or they work some other provisions, we take that into consideration.
Okay.
We just don't want you there as a patron.
Okay.
But do let Ms. Tidwell know, because if people happen to know you and happen to know you're on probation, a lot of times we get calls
Yeah.
saying, I saw so-and-so at the bar. And the other thing is sometimes if you work at a restaurant that serves alcohol, that's not a violation anyway.
Okay.
If it's primarily a bar,
job. Yeah.
right? So talk to the probation agent. It's best to keep in communication there. It looks like when you're not drinking, you don't have trouble.
No.
When you are drinking, it looks like you have trouble.
Thank you. Yes.
All right, we'll be adjourned on this case. Thank you.
Okay. Thank you.
Excuse me, Your Honor.
Thank you.
Yes,
Did you state
Yeah.
that there was no contact with a victim?
there was no contact with Lana Price.
Yes.
Okay, thank
That's
you.
my-
So there were two. Yep. So is that your mother-in-law?
Yes.
Right now, there's no contact with Lana Price, but his wife, he can have peaceable contact with, Lori Justice.
Thank you.
All right, thank you. We're all set.
Your Honor, how do I go? Well, Susan, let me know about the tether.
Scram tether? Yeah, she'll be in contact with you.
Okay.
Yeah, thank you.
Your Honor, Miss Rose should be here in just a moment. Did you want me to bring in Mr. Schmidt, or would you like me to wait? They said she'd be in there in just a second.
Yeah, let's bring in Ms. Schmidt. You're all set, Mr. Duke? Yep, looks like he is. Is it Mr. Schmidt?
Yes, sir. Brad Schmidt.
Okay, trying to find my documents for that. All right, we're calling case of the people, state of Michigan versus Brad Schmidt, file 21-0037 SM. Counsel, identify yourself for the record.
Peter Durant on behalf of Brad Schmidt, who is appearing via Zoom, Your Honor.
All right, today's time and date set for sentencing. Take a look here. Looks like Mr. Schmidt had served a fair amount of time in jail. Let me check that. Katrina, do you know if there's a victim in this case that wishes to appear?
Your Honor, I did not receive word from the prosecutor's office that a victim would be appearing.
All right. Mr. Durant, elocution on behalf of your client.
Thank you, Your Honor. So Mr. Schmidt doesn't have a criminal history appearing before the court today. He acknowledged that he had inappropriately done something. He pled guilty to the embezzlement charge. Based on the amount of restitution required, I believe that it would be in this court's best interest to set fines and costs at a minimum, as the amount is going to be significant, and Mr. Schmidt is going to be needing to work very hard to pay that off amount to make sure that all parties are made whole. Thank you, Your Honor.
All right, thank you. Mr. Schmidt, anything you wish to say in your own behalf?
No, sir.
All right, no victim appears. The defendant has no prior criminal history. The law has changed. It says in these types of cases that I'm not to order probation or jail, barring some circumstances, only fines and costs or community service. I believe that this case would fit into that category. I'm going to sentence the defendant to $75 crime victim rights fee, a $50 state assessment fee, $3,000 in restitution. And I'm also going to order 80 hours of community service that will need to be done over the next 6 months. You'll need to be in contact with the probation department. You are not on probation, Mr. Schmidt, but that's the people that I have to manage the community service. And so I want you to give back to the community that you have taken from. So you'll have 80 hours to do over the course of 6 months. If you do not do that, I could hold you in contempt of court. Contempt of court's like its own crime, punishable by up to 93 days in jail and up to $7,500 in fines plus court costs. However, today you're sentenced to $125 of various costs, which is the crime victim rights fee and the state assessment fee, and the $3,000 in restitution. You have 21 days to appeal the sentence, 14 days to request a court-appointed attorney to do that. Otherwise, we'll be adjourned on your case. Thank you very much. We're all set.
Thank you, Your Honor.
Mr. Durant, you ready to proceed on Ms. Rose's case?
Yes, I am, Your Honor.
All right, we are on the record of the people. Go ahead, Katrina.
There we go. I do need the jail to unmute. There we go.
We're on the record of the people, State of Michigan versus Jessica Jean Rose. This is file 21-0101SD. Counsel, identify yourself for the record.
Peter Durant on behalf of Jessica Rose, who is appearing via Zoom from the Midland County Jail.
All right, today's time and date set for sentencing. Have you an opportunity to review the pre-sentence investigation form?
Your Honor, I was instructed that there was no PSI. Never mind. I'm sorry. I was looking at the other case. I apologize, Your Honor. I did get a chance to read this PSI. I was confused based on the earlier conversation we had. But yes, I did have a chance to read the PSI. I would agree that the recommendation is fair and accurate. No corrections at this time.
Okay. Any allocution on behalf of your client on this case?
On this case, Your Honor, Ms. Rose has been sitting incarcerated. She acknowledges that she made some mistakes. She has taken responsibility for those. Based on the current situation, I believe that the recommendation is accurate, and Ms. Rose is going to be doing her best to address these issues that have come up in her past so that she can continue to try and move forward and become a valuable member of the community again. Thank you.
All right. Ms. Rose, anything you wish to say in your own behalf?
No, thank you, Your Honor.
Okay. This sentence, I think you're sitting in jail also for a contempt, so this has no impact on that, but I'm planning on giving you time served on this case. That means that once you're done with whatever the contempt amount is, then you're done with these cases. So I'm going to sentence you this way. Because there's restitution in the amount of $1,000, let me just check to see if there's any victim that wished to appear. Katrina, was there any victim that wished to appear in this case?
Not that I'm aware of, Your Honor.
Okay. So I'm going to sentence you in this case to $75 crime victim rights fee, a $50 state assessment fee, no other fines and costs because restitution is so high. So it'll be $1,000 in restitution. I'm going to sentence you to 82 days in jail with credit for 82 days served. However, if you're sitting still on the contempt, you have to finish out whatever the contempt is for that. So you have 21 days to appeal this sentence, 14 days to request a court-appointed attorney to do that. Will be adjourned on this file. However, you have to stay put because there's a new case that I have to arraign you on. So we're back on the record in the People's State of Michigan versus Jessica Jean Rose, file 21-0625FY. Counsel, identify yourself for the record.
Peter Durant's on limited appearance for Jessica Rose for the purposes of this arraignment.
All right, Ms. Rose, Mr. Durant is only going to be your attorney on this case just for this hearing. After this, if you wish to have a lawyer, you have to request a court-appointed attorney or hire your own. But I do need to read to you the charges in this file. I'm going to show them on the computer screen. If you would tell me if you see them. Is it on the computer screen?
Yes.
All right. In this case, ma'am, you're charged with 2 felonies of resisting and obstruct a police officer. It is alleged that on about March 22nd of this year at 4560 North Island Drive in Edenville Township, Midland County, Michigan, that you did assault, batter, wound, resist, oppose, or endanger Deputy Charbonneau, a sheriff or deputy sheriff of the county of Midland, and the sheriff's from the sheriff's office, and that the defendant knew or had reason to know he was performing his duties. If you're convicted of this crime, it's a felony punishable by up to 2 years in prison and or $2,000 in fines plus court costs. Consecutive sentencing may be imposed under 750-506A if the assault took place in a place of confinement, or under 750-81D6 for any other violation arising from the same transaction. That's important because you're charged with a second count of resist, obstruct an officer on the same date, time, and place. It is alleged you did assault, batter, wound, resist, oppose, obstruct, or endanger Sergeant Milks, a sheriff or deputy sheriff of the Midland County that the defendant knew or had reason to know is performing his duties. If you're convicted of this crime, again, it's also punishable by up to 2 years in prison and or $2,000 in fines plus court costs. And again, consecutive sentencing may be imposed if it took place in a confined place of confinement or for another violation arising out of the same transaction. At this point in time, do you understand the two charges and the maximum penalties that I've just read?
Yes.
All right. Mr. Durance, how do you advise your client to plead to these two charges?
I'd advise her to plead not guilty, Your Honor.
Not guilty plea will be entered in the records of this court. Ms. Rose, your next date for court will be on June 1st at 1 o'clock for a probable cause conference. You will have a preliminary examination if you choose on June 8th at 2 o'clock. Are you planning on hiring your own attorney or requesting a court-appointed attorney for these felony cases?
I'm going to have to request a court-appointed attorney. And then do I have a bond on that or no?
Yeah, I'm gonna address that right now. So
Okay.
at this point in time, Mr. Durant, your client's been sitting in jail for 82 days. I think she may still have a few more days on the contempt. I was concerned about her stability and her substance use. I think she is about as clear-headed as I've seen her be during this entire time. I think that she may have some tools to be out on bond on this case. The tricky part is if I give her a PR bond today, that she will receive no credit towards this case, but I presume she would probably rather be out and take the risk of not having any credit on this case. But I leave that to your argument, sir.
Thank you, Your Honor. Based on the limited amount of time, I believe that she still has less to serve on the contempt. I would advise and I would ask for a personal recognizance bond based on the maximum penalties for this case and based on the de minimis amount of good time she would receive for being in jail that you would miss out on while being in bond. I would recommend that my client ask for a personal recognizance bond at this time, so that way upon the completion of her sentence for the contempt hearing, she is able to go and begin starting to work towards paying some fines from the earlier cases, as well as possibly seek a counsel for the new cases. Thank you, Your Honor.
Ma'am, I do see you had a certificate. I have been made aware that you're doing a lot better. That's the reason why I'm
Yes.
considering the personal
I
recognizance
was very
bond.
proud of that. Yeah.
Yep, you should. No, you should be. You should be. The reason why we try to get your attention. Sometimes we have people who have no prior criminal history and they just really go off the rails. And we
Absolutely.
can't save them from themselves unless we give them a timeout, an adult timeout, which is the jail.
Yes.
I think we've
Mhm.
accomplished that. So I'm going to take another risk on you. I'm
Your
going to give
Honor?
you a PR bond. Yes.
I apologize. I do have a prosecutor that is logging in right now.
Okay. Good morning, Mr. Schwinski.
Good morning.
Appear you want to make an appearance on the Jessica Rose case.
Yes, Your Honor. Patrick Swinsky for the people.
Mr. Durant had made an argument. He's here for limited purposes. I had instructed him, unless I hear something significantly new, my plan was to issue a PR bond on this case. She's been sitting for 82 days. This case actually could have been charged. It's not a criticism. It's just a fact stating. It alleged to take place on March 22nd. It wasn't charged till May 12th. So had she been charged at that point in time, we probably would have looked at bond a little bit differently, but I'm willing to listen to an argument in the prosecutor's office regarding bond.
This is 21625 FY.
Yes.
No, I have no objection, Your Honor. I'd leave it to the court's discretion. Thank you.
Oh, okay. So, Ms. Rose, I'm going to let you out on a PR bond once you finished your sentence, because the contempt, once I set that, that's set in place. So I don't know. I suspect you have a few days left, but I've stopped trying to figure out the jail math. They'll tell you, you'll know. But you'll be out on bond, sitting in jail. So realize you won't receive any credit on this case if you need it down the road. But I'm going to put you on pretrial services again, but this time it would be with Ms. Rebecca Holm. Ms. Holm will have you get a biopsychosocial assessment done. Follow all the recommendations. I think you understand what happens if you do not follow the recommendations.
Yes, sir.
Okay. So I want you testing, and I want you consuming any alcoholic beverages, illegal drugs, or recreational marijuana subject to random drug and alcohol testing. You should be clean now, and we don't want to see you come back into the jail. But obviously, if you violate the bond, you could have your bond revoked. So no threatening, intimidating, violent, aggressive, or disorderly behavior. I suspect, and I don't want you commenting, But I suspect that this is when they went to arrest you on some of the other bond terms for the other cases. And I get that you did not want them to do that, but resisting and obstructing a police officer when they're doing their job is against the law. So I do see that and it is within the prosecutor's discretion to charge this, but I also note that this was alleged to have taken place right when you went into jail. And so had I issued the bond at that point in time, I might have set a higher bond to make sure you got your head clear. And it looks like your head's clear to me. So I'm going to take another shot. The next time we'll have to be is on June 1st. The issue though is that that will be by Zoom. So we need to have either an email or a telephone number that we can send you information so that you can Zoom in. Do you have a telephone number that we could have?
I do. It is 989-750-6208.
Okay. And do you have an email address if we need to send you instructions how to Zoom?
I do. It is Jessica, JESSICA, J Rose, ROSE 89@gmail.com.
Okay. All right. We'll send you the instructions. I think you probably will be out of jail before then, but if not, we'll bring you up this way because again,
Okay.
you're done with the misdemeanor case and you don't have to report to anybody in district court. You now report to Miss Rebecca Holmes. She is in charge of the pretrial services for circuit court. Okay. All right.
Yep.
Anything else we need to place on the record at this time, Mr. Durant?
Not at this time, Your Honor. Thank you.
Mr. Shawinski?
No, Your Honor.
All right. We're all set, Miss Rose. So we're hitting the reset button. We'll see how you do
Okay.
this time out. Okay.
Thank you, Your Honor.
Thank you.
Your Honor?
We'll be adjourned. Yes.
I'm sorry, just to clarify, you did appoint a court appointed, correct?
I'm sorry. Yes, I did appoint a court appointed attorney. She's been in jail, has no access to funds, I presume. And so I'm going to appoint an attorney for her in that case. All right.
Thank you, sir.
We'll be adjourned.
Thank you, Your Honor.
Thank you. I'm going to